The president was hoping that the CDC's unconstitutional power grab could be tied up in courts for at least a month or two.
But here's the deal. I can't guarantee the court won't rule that we don't have that authority. But at least we'll have the ability to, if we have to appeal, to keep this going for a month. At least, I hope longer.
The idea was to hold up evictions through agency action and give Congress enough time to come back into session in the middle of September and then vote on the new eviction moratorium. The United States Supreme Court, however, would have none of it, and in a 6-3 decision just ruled that the eviction moratorium was illegal. In this video, I'm going to break down the court's decision and what it means for landlords going forward. Coming up. Hey guys, if we're just meeting, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. I've been successfully investing in cash flowing rental properties since 2011, and I currently have over 70 units in my real estate portfolio. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing and personal finance. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoy the content in this video, hit the like button and comment down below. And as always, whenever I'm discussing legal or financial topics, just remember, nothing that I say should be construed as legal advice, and the opinions that I provide are my own alone and don't necessarily reflect those of my law firm or any of my business partners. So let's talk about the eviction moratorium and the Supreme Court decision that just invalidated it. So the eviction moratorium was originally supposed to expire on July 31st, 2021, and in fact did expire. Prior to that, several landlords and realtor associations filed a complaint in federal court seeking to invalidate the pre-existing eviction moratorium on various constitutional and statutory grounds. And previously, district court decided that the eviction moratorium was illegal because CDC did not have authority to actually promulgate it in the first place. However, because the CDC was appealing that decision from that district court, the district court decided to stay the execution of its own decision until the higher courts, the circuit court and possibly the Supreme Court, would decide that appeal. So even though the district court back in April or May of this year decided that the eviction moratorium was not legal and that CDC did not have authority to issue that moratorium, it nevertheless stayed its own decision until that appeal could be decided. And so what happened was the next level court, the DC Circuit Court, issued its own decision on appeal, keeping the moratorium alive and continuing it until its supposed expiration date on July 31st, 2021. It finally got to the United States Supreme Court in June of 2021. And on June 29th of 2021, the Supreme Court issued a very short decision where, in fact, the only justice that provided any opinion was Justice Kavanaugh, where Justice basically said that he was agreeing with the majority because the CDC eviction ban was going to expire at the end of July anyway, and there are only a few more weeks to go. So even though he agreed that CDC did not have the authority to issue the eviction moratorium, he was nevertheless voting with the majority to keep that moratorium going until the end of July. But he did say that in order for there to be any future moratoriums, that it had to be done by Congress and that CDC did not have that authority. So in light of this background, in early August, President Biden actually came out and held a press conference and essentially said that he had put it in the hands of the CDC to come up with a new moratorium, and that the idea here was to hold it up until Congress could eventually come back into session in September, and so that Congress can then rule on a new CDC eviction moratorium. The goal here from the Biden administration and many of the advocates for these moratoriums and for this specific moratorium was never to stop the moratorium. I know that the subsequent new CDC eviction moratorium says that it was supposed to expire on October 3rd, but the only reason it was expiring on October 3rd is because the belief is that when Congress gets back into session in the middle of September, they are going to vote and pass as a law a new eviction moratorium, which will presumably take us through the end of the year or possibly longer. And that's exactly what the intent here is. There's no intent to stop the eviction moratorium at some future date, at a reasonably near future date. The intent is to simply keep it going as long as possible, and chiefly because the money that the federal government appropriated and sent to the states, both during the Trump administration, the last months of the Trump administration, and during the first few months of the Biden administration, has not been fully distributed or anywhere near fully distributed by the states. That money went out to the states in January, February, and March of this year. And to date, I think the stats are something like 10 or 15% of that money has been distributed to landlords. And so instead of trying to put pressure on the states or perhaps state governments acting quicker to distribute this money to landlords that need it, the solution here is to simply continue extending the moratoriums and damaging and irreparably harming landlords in the process, who are potentially losing their properties, potentially going into ridiculous severe debt, potentially having tenants leave while they owe tens of thousands of dollars before this money gets to the landlords, and never being able to recover that money. And so that's the kind of the background of where we were. So the eviction moratorium, the new one, was issued by CDC on August 3rd, and it's supposed to have expired on October 3rd. And as you saw in the clip that I played in the intro, the president was hoping that this would get tied up in court and remain in effect at least through September. Well, it just so happens that, surprisingly, courts acted very quickly in this case. We had two decisions. We had the district court, the same court that originally issued its decision in April or May, issue a decision. And then we had the second level appeal court, which is the DC Circuit Court, also issue its decision in a matter of weeks. And now the matter came to the Supreme Court. And by the way, both of those lower courts ruled against the plaintiffs. The plaintiffs are the landlords and the realtor associations, and we're going to keep the moratorium in place. And so to me, it was actually surprising that they were doing that, number one. And number two, it was surprising that the Supreme Court acted and issued its decision as fast as it did, and also how detailed this decision was. And I just want to show you guys so you can see on the calendar, this is to go back to the point about the Biden administration intending to extend this for a month or two, and where the priorities are and where the interests are. If you look at the calendar, this is the 2021 Congressional calendar. And you'll see the red here is the dates on which Senate is in session, and the blue, light blue, is when the House is in session. And so if you look, August 3rd is when the new CDC eviction moratorium was put into place. House had already left. So the House was not in session at that point. Only the Senate was in session. And of course, you need both the House and the Senate to vote in majorities to actually pass a law, which is what they would need to do in order to congressionally extend the eviction moratorium. So they couldn't do that. So President Biden was under pressure to do something. And so he just went back to the CDC and told the CDC, come up with a way, consult with your scholars, your constitutional scholars, but come up with a way that we can hold this up until, and you can see purple is when House and Senate are both in session, until we can get Congress back in session fully, which won't happen until September 20th if they hold to this calendar, and then presumably vote on a congressional extension, which the assumption among everybody is that it would hold up in court if that's how the eviction moratorium was promulgated. And so that was the intent here. So keep that in mind. And so the Supreme Court just now issued its opinion, its new decision. And honestly, I'm surprised by how favorable the decision is in terms of the language and the rationale that the court gave for landlords in this decision. And I want to show you some sections of the decision, read some of those to you, because I honestly can't say it better than the court, and the court really said it really well. So here's the court's decision. And the other thing I want to say about this is just to comment on the different decisions that we've seen, because there actually have been quite a few lawsuits that have been brought since the eviction moratoria, both various state eviction moratoria and some of the federal eviction moratoria that have been promulgated previously, and what courts have decided in those cases. And almost across the board, courts have been very deferential to the governments, the federal government, the agencies, the state legislatures that have issued these moratoria, and they've been very resistant to grant any relief to landlords. And what's interesting is that they provided a few different rationales for why that was the case. One of the rationales that courts have provided in denying relief to landlords has been that the eviction moratoriums are finite in duration. So they all have a certain expiration date, and because there's a limit to how long they go for, which previously was 2-3 months, maybe a little bit more than that, but just in a matter of months, that the eviction moratoriums will expire, and therefore you're not being deprived of your property rights. It's not a deprivation. It's simply just a delay. And so for that reason, your rights have not been violated, and we're going to allow those moratoriums to continue. So that has been one rationale. And what's interesting about that, of course, is that here we are more than a year and a half since this whole thing began, and the moratoriums are still in effect. They're still being extended on the state level in a lot of cases, and obviously on the federal level. And so this rationale has continued despite these extensions. The second type of rationale that courts have been using is that landlords can still obtain relief in the form of money. That, yes, they are unable to evict tenants, but it doesn't mean that tenants don't have to pay rent. And it's this interesting semantics game that the courts are playing, because this completely ignores the reality, which I think a lot of courts that are issuing these decisions really know and understand this reality. But you can't collect a judgment against a judgment-proof tenant, a judgment-proof litigant. What that means is that you can obtain a judgment. Let's say the eviction moratorium is lifted. And by the way, this was true for years. This is not unique to this particular situation with the pandemic and the eviction moratorium. Anytime you get a judgment against a person who has no assets and nothing that you can seize or obtain, you're essentially getting a worthless piece of paper in that judgment. So in this case, what's likely to happen is that whenever the moratoriums are lifted and whenever landlords are able to go to court and obtain judgments against tenants, the next step is to try to collect on that judgment. So first you got to get a judgment. That's going to take you a lot of time, a lot of attorney time and money, and you're going to have to chase the tenant. You're going to have to serve them properly. They may even move out of your property by then. And so now you're in a situation where you have a judgment, and it's just a piece of paper that says, yes, this tenant, this person owes you money. Now, how do you collect on it? Well, you have to start another proceeding. You have to start some kind of a collection proceeding against that person. And you have to find out where they work, what assets they have, which again requires serving the judgment debtor with papers, court filings, and trying to find that information about them, which is not easy at all. And the less assets a person has, the harder it is to get money from them, even if they owe you, even if the court said that they owe you money. So if a tenant who by definition does not own property, doesn't have any property, real estate, you can't file a lien against any property. You can't use your judgment to place a lien, and you can't collect on that. You may be able to garnish their wages if you can find out where the heck they're working, but they may not be working. And in fact, a lot of these tenants are not working because they don't have to work, because the Biden administration has been giving them, and the Trump administration before that as well, has just been giving them free money over and over again, extended unemployment benefits, extra payments, stimulus payments, and of course, the free pass on rent, because there's no consequence for not paying rent for a year and a half now. So most people have not gone back to work. But even assuming your tenant, your judgment debtor, has gone back to work, and you can find out where they work, and you can actually go through the proper process in your state to file the paperwork to garnish their wages, most states have limits on how much you can garnish. In fact, they have such strict limits that maybe you won't be able to garnish anything at all, depending on how much this person is making at their work. And if you are able to garnish something, maybe what you would be getting is something like $10 a paycheck, $20 a paycheck. And if this person owes you $10,000 because they haven't paid your rent for the last year or more, in many cases, it's a lot more. And in larger metropolitan areas, it's a lot more. You're never going to see that money, because as soon as that person leaves one job, which a lot of lower income people end up moving from job to job a lot, you're not going to be able to collect from that first employer. You're going to have to do the process over again, find where they're working now, and submit the same paperwork to garnish their wages at their new employer. So all I'm saying is that it's a complete nightmare, and it's a complete improbability that landlords are going to get paid any of this back rent, except for maybe they can get paid through rental assistance, which that's a whole other topic. I have quite a few videos on this topic now talking about rental assistance and deficiencies in it, especially in states like New York and California and other states. But essentially, the problem with rental assistance in getting landlords paid is that it requires, in many cases, tenant cooperation. And if you have a pretty bad relationship with a tenant, which if they're not paying you intentionally, and if you have to take them to court and they've been evicted or there's been court litigation, then they're not going to cooperate with you. They're not going to cooperate with your application for rental assistance. And so that goes out the window. And so landlords are not going to get paid in those scenarios, even if they get a judgment, even if the eviction bans are lifted. And so that's the point. And so the second rationale that courts are using is also kind of an empty promise to landlords and essentially lip service in order to get to the ultimate result that the courts are trying to get to, which is allow the moratoriums to continue. Finally, the last argument that courts have made so far prior to this Supreme Court decision was that they're weighing the balancing of the equities, the hardship to landlords against the public policy. And that is either public policy in keeping poor people who are out of work from becoming homeless, or more recently, as with the CDC eviction moratorium justification, not only keeping those poor, disadvantaged folks in their homes, but also preventing the spread of the pandemic and the spread of the disease. And so it's interesting what the court says about these particular arguments in this decision. And I just want to read to you some of the passages because I think they're very illuminating and very interesting that the tide seems to be finally turning with this rationale from the Supreme Court. Perhaps some of the lower courts in future decisions, which we're likely to see, are going to use and rely on as well. So I'm not going to read the whole thing, but I'm just going to highlight some of the passages. So the court says here, it would be one thing if Congress had specifically authorized the action that the CDC has taken, but that has not happened. Instead, the CDC has imposed a nationwide moratorium on evictions in reliance on a decades-old statute that authorizes it to implement measures like fumigation and pest extermination. It strains credulity to believe that this statute grants the CDC the sweeping authority that it asserts. So what statute was it that the CDC was relying on? Well, that statute was Section 361A of the Public Health Services Act, which provides as follows. The Surgeon General, with the approval of the Secretary of Health and Human Services, is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states or possessions, or from one state or possession into any other state or possession. So cross state lines or cross border lines into the United States. For purposes of carrying out and enforcing such regulations, the Surgeon General may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary. This is the section in the law that the CDC has relied on in order to impose this moratorium on the entire country. And interestingly, the Supreme Court said that regulations under this authority have generally been limited to quarantining infected individuals and prohibiting the import or sale of animals known to transmit disease. So the court points out that the government, the CDC, is saying that it's relying on the first sentence of this paragraph, where it says that it can take whatever measures it deems necessary to control the spread of the current disease. And the court writes, but the second sentence informs the grant of authority by illustrating the kinds of measures that could be necessary. And those were, as I read, inspection, fumigation, disinfection, sanitation, pest extermination, and destruction of contaminated animals and articles. These measures directly relate to preventing the interstate spread of disease by identifying, isolating, and destroying the disease itself. The CDC moratorium, on the other hand, relates to interstate infection far more indirectly. If evictions occur, some subset of tenants might move from one state to another. and some subset of that group might do so while infected with COVID-19. This downstream connection between eviction and the interstate spread of disease is markedly different from the direct targeting of disease that characterizes the measures identified in the statute. So what does that mean? Well, the court is basically saying that the statutory authority that you, CDC, is relying on doesn't actually give you the authority to do what you're doing. The examples that are given in the statute are nowhere near what you're trying to do here, which is impose an eviction moratorium, get into the realm of housing, and basically curtail the ability of millions of people to exercise their property rights in all states across the country, no matter where they reside. That is an enormous amount of authority that the CDC is grabbing, which it clearly does not have, at least according to the majority. And this is the key quote from the court. And this is very interesting. The court says, "Indeed, the government's read of Section 361A would give the CDC a breathtaking amount of authority. It is hard to see what measures this interpretation would place outside the CDC's reach, and the government has identified no limit in Section 361A beyond the requirement that the CDC deem a measure necessary. Could the CDC, for example, mandate free grocery deliveries to the homes of the sick or vulnerable? Require manufacturers to provide free computers to enable people to work from home? Order telecommunications companies to provide free high-speed internet service to facilitate remote work? This claim of expansive authority under Section 361A is unprecedented." And that's exactly right. If the CDC has the authority to impose sweeping eviction moratoriums, then why does it not have other authority? And that's the problem. There's no limiting principle here. The CDC can power grab anything, and it can tell us to do whatever it wants us to do because they have this necessary language in the statute. And that is what the court is saying is completely outside the bounds. The court is saying that Congress did not intend to provide this much power to one agency of unelected bureaucrats. And the court continues here. "The moratorium has put the applicants, along with millions of landlords across the country, at risk of irreparable harm by depriving them of rent payments with no guarantee of eventual recovery." And that's exactly what I was talking about. There's no guarantee that landlords are actually going to get paid, regardless of the rental assistance or any judgments that they may obtain in court. Despite the CDC's determination that landlords should bear a significant financial cost of the pandemic, many landlords have modest means. And preventing them from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, and that is the right to exclude. As harm to the applicants has increased, the government's interests have decreased. Since the district court entered its stay, the government has had 3 additional months to distribute rental assistance funds to help ease the transition away from the moratorium. And that's back to the other point in that governments have been very, very slow and inefficient in distributing this funding. The rental assistance funding is still largely undistributed, despite the fact that we are now approaching 8 months since the initial federal funding was appropriated. Whatever interest the government had in maintaining the moratorium's original end date to ensure the orderly administration of those programs has since diminished, and Congress was on notice that a further extension would almost surely require new legislation. Yet it failed to act in the several weeks leading up to the moratorium's expiration. It is indisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant. But our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. It is up to Congress, not the CDC, to decide whether the public interest merits further action here. And that is where we are. This was a 6-3 decision along party lines. The 3 Democratic justices on the court all voted in dissent, and the 6 Republican-appointed justices voted in favor of this decision and striking of this moratorium. So now this moratorium is no more. On the federal level, landlords are once again able to begin eviction proceedings or resume existing eviction proceedings. However, going back to the calendar that I showed you earlier, when Congress is expected to return September 20th, where both the House and the Senate will be in session, it is possible, and maybe even likely, depending on how many votes they can garner, that a new eviction moratorium will be passed through congressional action. And if it happens it's likely to probably go for another several months, and I foresee it going through the end of the year. But until then, we have a gap in time, assuming that your state does not have its own eviction moratorium, which I did a video on New York State, the state where I live, where we have a hodgepodge of different moratoria and different tenant protection laws that were in existence. And just recently, on August 12th, the Supreme Court issued a decision striking one of those moratoria and protections in New York State. So in New York State, there's a little bit of an ambiguity as to what can be done right now because another law is still in effect. But depending on your own state moratorium, if you don't have one, you may be able to begin eviction proceedings against non-paying tenants because the federal eviction moratorium is no longer in effect. But you might have only a very short window. I'm making this video on August 28th, and if it's true that Congress comes back on September 20th, and who knows how long it will take to actually vote through a new law that would impose a new eviction moratorium, you may only have a couple of weeks, 2-3 weeks at most, in order to complete an eviction. And unfortunately, with the courts likely being backed up and with the time requirements in terms of service and filing in court, it may not be possible to actually complete any evictions during this time. So the hope is, for myself and many other landlords out there, is that there won't be a new eviction moratorium on the federal level, and that landlords will be able to obtain relief in court, recover their properties, and hopefully start being able to collect new rent from paying tenants and get back on track and avoid financial disaster. With that said, that's going to do it for this video. If you got value from it, do me a favor and hit the like button. And if you haven't yet subscribed to my channel, definitely subscribe so that you don't miss any of my future content. If you have any questions for me about anything that I said in this video or anything that I didn't cover that you wanted me to cover, let me know in the comments below. But thanks again for watching. I really appreciate it. Have a great day, and I will see you in the next one. Take care.